meeting to order. If everyone could please check your cell phones and make sure that they're turned off. This is our first meeting for the new year, and we have a new member, Matt Young. We'd like to welcome Matt to the board. For those who don't know Matt, he's a civil engineer, and I'm hoping that he brings lots of experience to the board. We also have a new planner with us tonight, Garrett Moyes. Welcome. Our first order of business is election of chair and vice chair. Do we have any nominations for chair?
Madam Chair,
Mr. Pollack?
I'd like to nominate Kathy Moore for chair.
Are there any other?
Second.
Are there any other nominations? Seeing none, we'll call the vote. All those in favor say aye.
Aye.
Opposed? Thank you. Next is nominations for vice chair.
Madam Chair,
Mr. Lopez?
I nominate Bob Pollock. Second.
Any other nominations? No second nominations, no. Are there any other nominations for vice chair? Seeing none, we'll call the vote. All those in favor say aye. Aye. Opposed? Congratulations, Bob. Okay, the next item on the agenda is approval of the minutes from the December 9th, 2014 meeting. Do we have a motion?
Madam Chair,
Mr. Pollack?
I'd like to make a motion to approve the minutes with one correction on the motion. Let's see, it was
1612, Bob.
it was 1612. Okay, yeah. Okay, the motion, I guess it was 1612. It said that William Sheridan made the motion and Mr. Lopez seconded it. It was actually the reverse of that.
Mm-hmm.
Okay, so your motion is to approve the minutes with the correction to the comments regarding ordinance number 1612 to reverse the maker of the motion and the seconder.
Correct.
Is there a second?
Second.
Mr. Lopez, is there any discussion? Seeing none, we'll call the vote. All those in favor say aye. Aye. Opposed? Motion carries. The next item on the agenda is public comment. And this is the time for anyone from the public to speak to the board about either any item that's not on tonight's agenda or the item that's a public meeting item. If there's anyone here wishing to speak to the board at this time, please come to the podium. I will state your name and address for the record.
My name is Mark Jones. My address is 2601 Turtlehead Cove. I am one of the affected property owners.
I'm sorry, affected property owners for
what's on the agenda this evening.
we have two different properties.
I thought it was the same issue. I'm in the sanctuary.
Okay.
Okay. My
Madam Chair?
Oh, that's a public hearing
That's
item.
public hearing, yeah.
You'll get to speak about that item when we get to it.
Sure, no problem.
Okay?
She might want to get a form, Madam Chair.
Yeah, there are forms at the back
If you wish.
in that slot next to the door that you can fill out.
Explain what the public.
Yeah, the public meeting item tonight is Emporia Hammock subdivision. If there's anyone here wishing to speak about that item or anything not on the agenda. Seeing none, we'll close public comment. The next item is the public meeting for the PSP for Emporia's Hammock subdivision. Do we have the applicant here? Will you state your name and address for the record?
David Stokes, Madam Moorhead and Glunt, 431 East Horatio Avenue, Suite 260, Maitland, Florida. I'm here on behalf of Taylor Morrison for the Emporia Hammock PSP. The project is 52 single-family residential lots. The property is located at the northeast corner of Lake Charm Drive and Panther Street. The zoning is R1, the land use of LDR, maximum density of 3.5 units per acre. Currently, the property is net density of 2.13 units per acre. We meet the requirements of the R1 zoning district for minimum lot size, minimum lot width, maximum height, and setbacks. We respectfully request your recommendation of approval to the City Council.
Is that it?
Unless there's questions from the board.
Okay. Are there any questions of the applicant at this time?
Madam Chair,
Mr. Wright?
I have a question. It's in the PSP drawings themselves. For the benefit of the board, it's on page PSP-1. There was a note that was revised and added that basically the city of Oviedo is to participate in the construction of the southern half of the sidewalk of Lake Charm Drive, and I'm just trying to have a clear understanding of what the expectation on that was.
The portion of that sidewalk goes through a ditch and a portion of the wetland area, and it's extremely difficult due to those circumstances. So in discussions with Mr. Bobby Wyatt, he agreed that the city would help with the construction of that sidewalk.
Can you help me understand where it says southern half? I mean, what is there a limit? I mean, I can look at the drawing and
Sure. The
kind of see
intent,
where your lots are and kind of get an idea what the extent of that is.
sure, approximately adjacent to Lot 6 and south from there. Plus or minus, depending on final engineering design.
Very good. The rest of the questions I'll save for staff.
Okay, thank you. May we hear from staff?
Thank you, Madam Chair. This is a request for the Planning, Zoning, and Appeals Board to consider and make a recommendation for the preliminary subdivision plan of a 52-lot, single-family residential development. The proposed subdivision is located on the north side of Panther Street and the east side of Lake Charm Drive. The total land area is approximately 38.31 acres. The proposed subdivision comprises 2 parcels. The owners are Tomai T, Din Thuan V, and others. The applicant is Taylor Morrison of Florida Incorporated, and the applicant's consultant is Madden Moorhead Glunt Incorporated Civil Engineers. The subject property was annexed into the city by ordinance number 1586. The annexation request comprised 38.31 acres and was adopted by City Council on August 4th, 2014. On the same date, the City Council adopted future land use and zoning map amendments pertaining to the 38.31 acres of the Emporia Hamwick recently annexed properties. The future land use designation of the subdivision is low-density residential, and the zoning district is R1. The subdivision will have 2 retention pond areas and 2 recreation open space areas. The recreation areas will be located to the northwest and southeast in the subdivision. Lots 51 and 52 are to be designated for model homes as well as a sales office. The entrance to the development will include a brick wall entrance feature and will include landscaping. Interior landscaping will include a canopy tree for every 50 feet of interior road right-of-way. All LDC required street trees along Lake Charm Drive and Panther Street are not able to be placed in the right-of-way due to overhead utility lines. Street trees are not able to be placed in the right-of-way of unimproved Hammock Lane due to existing vegetation. The required trees have been placed internally to the site in accordance with LDC Section 12.3B3F. According to Public Works, the property frontage bordering the west side of unimproved Hammock Lane right-of-way, which is to the east of the property, is not considered a street as described in LDC Article 18 definitions. Therefore, sidewalks will not be installed. The 2.81 acre impact to the wetlands shall be mitigated prior to site development plan final engineering approval. Site data number 33 on page PSP1 outlines that the applicant will provide mitigation requirements to demonstrate comprehensive plan compliance before final engineering approval. Concurrency, transportation, and environmental requirements have been satisfied. Potable water and sewer service will be provided by the City of Oviedo. Solid waste capacity is available through Seminole County. The applicant proposes the subdivision to be a gated community with private right-of-ways. The applicant also proposes to place a bus stop at the entrance to the subdivision for students to wait for school buses in a safe and sheltered site. The Development Review Committee considered Site Development Order Number 438-15 at its meeting on December 18th, 2014, and Theorat recommended approval. The City Council will consider Site Development Order Number 438-15 on January 20th, 2015, beginning at 6:30 p.m. in the City Council chambers. Staff recommends that the PZA recommend adoption of the Resolution 2949-15, approving the Emporia Hammock Preliminary Subdivision Plan, subject to the conditions contained within Site Development Order Number 438-15. This concludes my presentation, and I'm available for questions.
Thank you. Are there any questions of staff?
Madam Chair?
Mr. Wright?
I met with staff earlier today, so I have several questions. Going back to the documents, the PSP, first sheet, they're asking for applicant's asking for a waiver to remove the requirement for the sidewalk to be constructed, payment, sidewalk funds for a hammock lane. I don't necessarily remember that that's a waiverable item for us, and I think that based on discussions that road is never going to be built because it's in the wetland. I think I don't necessarily know that we need to put a waiver on that.
I'm sorry, can you speak up? That's better.
That's considered not to be a street according to our definition. Not considered a street. Not exactly that requirement. It's just that it's not a street per the definition.
Is there a method that we can document that from the city's perspective? Letter, it's something in writing that we can?
We do have, oh, I was in the wrong thing. We do have the letter from the city engineer that I can read for you, and we can attach to the documents of the project. Regarding Emporia Hammock and the request to not construct sidewalks along the Hammock Lane right-of-way, the LDC definition for a street is, quote, any public thoroughfare, street, avenue, boulevard, or space more than 20 feet wide which has been dedicated or deeded for vehicular use by the public and which can be used for access by fire department vehicles. Whereas it has been deeded as a street through an older plat, it's not possible for the fire department vehicles to pass by that street. So it doesn't meet all the requirements to be considered a street. While the right-of-way exists, it is undeveloped and wooded. There currently is no public access or planned roadway construction. The right-of-way is also controlled by the county per my understanding. Right now, there is no access for the public or for the fire department, which in my estimation does not meet the definition as described above. As such, it would be my recommendation to grant the request in this scenario to not have to construct the sidewalk along the Hammock Lane right-of-way. So we have that letter from the city engineer.
Is that document sufficient then to include as part of the PSP approval this evening that we could?
Yes,
Okay.
yes.
Thank you. In conjunction with that, since we're not looking at that as a usable road by definition, we're not requiring that they would have to put the sidewalk. We are asking them to put the trees replacement that would be required on that same section of road. So I think what we're asking for is contradictory. So that would be something that I would probably want you to look at. That and for the board's member, there's, I think it's LA1 in the PSP. LA5, excuse me. When the applicant's required to look at tree replacement and especially the trees along the street requirements, you know, we're asking them that they need to have to put in 26 trees along a road that we say doesn't really exist or isn't really classified. So my suggestion would be that we remove that requirement in addition to the sidewalk requirement. So.
Yes, I believe that that's consistent with not considering it a street.
Second item is the survey, which is the second sheet of the PSP documents that we have. The Alta survey that was prepared by Grusenmeyer has a dedication of 150-foot buffer yard, or, they basically say to provide a buffer yard, and then in the notes on that same page, note 1, it's basically saying that we're supposed to provide an average of 150-foot buffer along the north property line with a canopy and sub-canopy trees that will achieve 100% capacity within 5 years. That's not necessarily, that's direct conflict with what the site plan is showing, so I'm not sure what, how we would address that.
We talked to the applicant after your observation, and I would request the applicant to come to the table and explain when that was done. And at that time, it was Seminole County, I believe. So if you could give us one explanation.
Sure. That is correct. That buffer,
I'm sorry, just name and address again so we know who's talking.
sure, David Stokes, Madden, Moorhead, and Glunt, 431 East Horatio Avenue. That buffer was associated with the Seminole County zoning when the property was next into the city and signed as city zoning. That buffer requirement went away. We actually haven't updated survey. That was an error on our part. Going to be the incorrect one with the PSP. So we'll get that corrected to staff for the following meeting.
Okay.
I
Thank you.
apologize.
No, it's fine.
I'm sorry, before you walk away, are there any other conditions on page 1,
Of the
sheet
survey?
1 of the survey that don't apply either?
No, ma'am. It was just a
Okay.
buffer.
Thank you.
You may want to just stay. I got a couple more, so
Okay.
you don't have to come back up.
Do you have any more of staff at this time?
Yes, it's continuing on is the going back to the landscape plan, and I think this was where I said LA1 was the sheet that I was looking at. Sorry. Again, it's ET1, excuse me. It's the existing trees. There's a note up at the very top of that sheet it's been clouded. It says all trees in this area to be removed. But there's at least 4 or 5, maybe 5 trees that are specifically off the property line, north of the property line, that are included in that obviously technically I don't think you can remove because they're not yours. I know I asked that question to staff earlier, and they were going to verify whether or not the count included those, or if it's just a drafting error.
Mr. Stokes, can you answer that?
Sure. I will verify with the landscape architect. I believe it's a drafting error, but I will confirm. Since we didn't prepare this plan and he's not here tonight, I'll have to verify with him.
Okay. Ms. Fruitt, were you guys able to verify the count?
12, 24, 8. It appears that they are included in here.
They are possibly
Yeah,
included?
because we have 124. We just have 1 9-inch oak, and one of the trees outside is 1 9-inch oak.
Okay. It's clear if you guys, if the board goes to the 4th sheet in the plans with the survey, you can kind of clearly see there's some trees up on that north line there's a 8-inch, a 9-inch, a 2 24-inch, and a 12-inch that are included in there that are outside of the survey property line, so.
But you are correct, if it's off our property, we won't be removing it.
Okay, I'm sure the owners will appreciate that.
Plan update aside, if it's off property, it's not touchable.
Okay. So obviously, staff, I guess, would be recommendation is that we get that corrected before, you know,
Yes.
the final approval goes to council and all that. I guess, last question is, for staff, and the applicant while he's up here, is this is a personal observation, in 15 years sitting on this board, I have never seen a disclaimer by your landscape architect that basically dismissed everything in our code, made recommendations that were completely against our code, and disclaimed that he has no responsibility for any item on it. So I'm having a hard time with it. I asked the question to staff. I don't believe the note belongs on there. I don't have any issues with the architect or landscape architect putting a disclaimer on his plans indicating, just like anything, but I wouldn't expect the civil engineers to certify the plan saying that we're certifying this is correct, but we don't agree with anything on it. So that to me is absolutely absurd. So not that we can really, as staff indicated, and I asked the question whether or not we could have it changed. There may not be a method for us to do that, but I'm going to make sure that my opinion is known, that I've never, again, 30 years in the industry and 15 years on these boards, I've never seen anybody professional in the industry ever put something on like this on the plans before. So want to make you aware of that. And I know the question I had for staff is whether or not we have any ability to change the language or request that the language be changed.
We actually spoke with the city attorney earlier today, and it was his recommendation that the disclaimer should not be accepted on the plans. And if they want, the applicant can write a letter expressing their belief.
And it would be added to the plans, to the file, but not on the plans.
From a recommendation standpoint for the board tonight, though, again, the idea is not to hold up any progress here, is that we could add a caveat to the approval or denial, whatever goes forward, that we could just ask for that disclaimer to be removed as part of our
Correct.
decision-making process.
We could add that as a condition.
Thank you. That's a blank on the word condition. Thank you. I have enough words already said, and I just put five conditions. So.
Oh, you're doing pretty good so far.
Final question, and this is for staff. Thank you for continuing to answer questions. It goes back to my original question regarding the sidewalk fund. In not many of my recollections, do we ever, it's the applicant's responsibility to pay for the full cost of the sidewalk installation along the full length of the right-of-way or pay into a fund. I was trying to find out what the reason was and kind of the impact, how much we're having to contribute to pay for that portion. I think he indicated around 600 feet of sidewalk.
We spoke with the city engineer about that, and what he told us is that today is not practical to install a sidewalk on a road about 300 feet from on Lake Charm Drive because of a drainage ditch there. What the city and the applicant are willing to agree on, and that's going to be subject of another agreement between the city and the applicant, is that the city would facilitate the installation of and piping of that part of the ditch so they could install the sidewalk. So that's what it's going to be done, and it's still subject to some type of agreement between the city and the owner or applicant for the installation of that ditch.
Do we have any estimate of costs or anything?
We don't have, because this is still in preliminary site plan, so that will be done at the stage of final engineering.
Okay. All right. Thank you very much. Thank you,
You're welcome.
Madam Chair.
Okay, are there any other questions of staff? Okay, nobody else? I have some. Oh, I'm sorry, not of staff, but I do have questions of the applicant now that we've heard staff's presentation. Mr. Stokes, can you come back to the podium, please?
One thing I would add to discussion about the sidewalk, that the city no longer has to maintain that ditch right away. It's a benefit to Bobby. Reason why he's in favor for
it. Okay, on page ET1 of the plans, going back to the cloud at the top of the page that says all trees in the area are to be removed, and I'm talking about the ones that are on your property. Can you explain to me why you're going to remove all of them?
For grading purposes of the subdivision, we have to fill to build these lots, and it's not possible because of the proximity of the trees, the amount of fill required, in the landscape architect's opinion that they will survive. You know, if you leave them and you fill 3 to 4 feet, in several years, they're going to die and be a hazard to the homes around them.
Okay. And I did have a concern that since your landscape architect was putting all of the trees inside the subdivision, that there are so many of them. But I guess one way to eliminate some of that is removing the requirement for the number of trees that would have been required along Hammock Lane. If that number is deleted, since Hammock Lane is not a street.
Yeah, that would have to be changed since it's not a street. The calculation will have to subtract
reduce some of
26
the-
from, yeah,
Some of the number of trees.
That's absolutely fine with us.
so it could be less.
And trust me, that hurts, that pains me to say that, because everybody knows I'm the tree lover up here. I'm always trying to get people to preserve trees.
It may be the first time I've heard less trees.
But I did have concern when I saw the drawings. It's on page LA1, for anyone who hasn't seen that yet. There are so many of them, and they appear to be somewhat close together. I did have concern that while you may put them in and they're saplings at the beginning, that some of them don't have much chance for survival. How many did you say that that's going to delete from their requirement? I'm sorry?
We have
26.
We have a land development code article, actually policy, that establishes that the replacement number, the number of replacement trees cannot surpass 2 times the number of required trees for the subdivision. So they are able to plant this number times 2 if their number of replacement trees is bigger. So according to the plans, they have, if you go to page LA5, the required tree table, you have a table there that it's called required trees table. You have 3 trees per lot. 3 times 52 is 156. And street trees is 1 per 50 feet, which is 185 trees. So the total is 341, the total number of required trees. According to the street trees table,
Are you looking at the table at the bottom left of that page, the mitigation calculation that you're looking for?
yeah, tree removal chart. So you are removing 18 plus 10 for N1, right?
And I have says we have an excess tree of 1, actually.
And you are providing 396.
Yeah, in that table, they tabulate the required by land development code of 341, trees provided of 396, and then the remaining trees for mitigation of 55.
Yeah, in this
Mitigation
case,
required
the the trees that they are required to replace are less than 2 times the number of trees that they would, let's say that if they had 600 trees that they would have to replace, or more, 700 trees they would have to replace, they could replace only 2 times 341. In their case, they are not removing as many, so they can replace only the ones that they are removing per our tables, according to the trees required.
Okay, but the trees that are required along the streets,
They are going to be planted.
those are not counted as
No,
for the ones being removed.
no.
So out of the 396 they were providing, if we subtract the ones that would have been along Hammock, subtract the 26, now they're only required, now they can subtract 26 from that total. So then it's only 370.
The removal table.
Which table?
Yeah, how many trees that are being removed?
I'm looking at page LA5.
You have to, they are removing different types of trees, and they are required, according to our tables, to provide, according to the caliper of those trees. It's the tree removal chart. So they are required to provide actually 54 trees at 2.5 caliper inches. They are removing less than that, but they are providing more because of the caliper of each one of the trees that were required. So they are providing the 341 plus 55, actually. And the mitigation is 54 that they are required to do that.
Okay, I'm not talking about the ones they're removing. I'm talking about the ones that are required along the streets. And since the landscape architect says he's not putting any along the streets because of overhead power lines, that all of those were going inside the subdivision instead.
Basically, our reach.
Yes, and they are. They are providing 390.
And that's what we're saying is
341.
that since Hammock Street really isn't a street,
So these ones, they don't have to provide.
right, so that's
But
26
the other ones, they
less.
do have to provide, and they are providing inside the lot, I mean, the tract, not, they are providing the internal streets. They have the 50-foot distance for each tree, and then they're providing more, 25 plus 26, 51 trees inside that are not, that they would have been required along Panther and Lake Charm, and they are providing those inside the subdivision, which they didn't put a legend here, but you can see, and we counted that, on LA2, all the trees that are inside the recreation area plus along the pond, these are not required. So they would be replacing the ones that they are not planting along Lake Charm and Panther.
I'm sorry, can you say that last part again?
The trees that are depicted on LA2, because this is bigger so you can see that better, in the recreation area and inside the pond. And I can see what else here. And also on page LA4, on the other pond, on the southeast extreme of the, can you see those trees there? These trees are not required, so they would be the ones that would be replacing the street trees that were supposed to be planted on the street,
Okay,
and they cannot be planted.
okay, I understand. But But since Hammock Street is not a street, then that's 26 less that they're
They
required.
can remove that requirement,
Yes,
yes. So
okay.
they would be able to take 26 less trees on those replacement trees.
Okay. And I'm assuming that that would be done 26 less and proportionately for the types of trees.
For that category of tree, yes, ma'am.
Okay. I think that was all the questions that I had about this. Does anyone else have any questions? Okay, thank you. This is a public meeting item, so we're not opening it up for public comment at this time. What's the board's pleasure?
Madam Chair,
Mr. Wright?
get my agenda out here real quick. I don't know what number we're looking at. I'd like to make a motion to recommend approval of resolution number 2949-15 with the following conditions. One would be that we remove the waiver note request off the cover sheet of the PSP. Two, that we remove the requirement for the street trees, 26 street trees located along Hammock Drive. And again, that's based on our definition that we provided tonight of what Hammock Drive by the city engineer is. Three, that we remove the landscape architect's disclaimer that's located on sheet LA1 of the PSP. And not conditions, but recommendations for that they correct the land survey with the revised survey that they indicated that they've provided or have in hand. And that the landscape plan be updated to ensure that there are no trees that are located north of the property that are slated for removal or included in the calculations.
Okay, and which, for clarification, which page was that?
I'm sorry, for the,
Did the trees that are not on their property show for removal?
PT1. PT1.
ET1.
sheet ET-1.
Second that.
Okay, Mr. Lopez, thank you for the second. Okay. Is there any discussion?
Madam Chair,
Mr. Wright?
so make sure staff has are they clear on what conditions we required or
Yeah.
any clarifications we need?
I would like to recap the conditions. The first condition would be to remove the waiver note request regarding the sidewalk along Hammock Lane. The second condition is to remove the requirement for 26 street trees replacement that correspond to the required trees along Hammock Lane, which is not considered a street per our city engineer. The third requirement is to remove the landscape architect disclaimer located on sheet LA1 of the PSP. The fourth condition would be to correct the survey regarding the landscape plans, to correct the survey regarding the 150-foot,
It was
because that was something actually that was
it was
talked about here.
provision to provide a 150-foot buffer
Yes.
along the north property line
So
in
actually,
note and graphic form.
yeah, to remove that from the survey. And actually, there are five. The fifth one would be to correct the landscape plans to update the calculations of the trees, removing the bubble of the trees outside of the property.
Thank you.
Is that
Yes, that's
clear
great.
for everyone?
Okay, is there any further discussion? Seeing none, we'll call the vote. All those in favor say aye. Aye. Opposed? Motion carries. This item will be considered by City Council on January 20th at 6:30 in these chambers. Good luck with your project. Patty, the record needs to reflect that Mr. Michael needs to leave at this time. Okay, the next item on our agenda is a public hearing on ordinance 1613, a comp plan amendment. That's M.I. Homes. Do we have the applicant present? Will you state your name and address for the record?
It's Jesse Hawk with Holland and Knight at 200 South Orange Ave, Orlando 32801. Good evening, everyone.
I'm sorry, I didn't hear, could you repeat your name?
It's Jesse Hawk.
Jesse Hawk?
Yes. MI Homes is requesting to amend the future land use and the zoning district of approximately 6.41 acres of property located on the north side of County Road 419 and east of Willingham Road and directly adjacent to the Sanctuary PUD development. MI Homes is specifically requesting a future land use amendment for approximately 4.74 acres from rural to low-density residential, and an amendment for approximately 1.67 acres located in the Econ River Protection Area from rural to conservation. We're also requesting a zoning district change for the entire 6.41 acres from agriculture to residential. The 6.41 acres that are subject of tonight's hearings consist of a portion of a 16.14 acre tract. The remaining 9.73 acres of that tract already bear the future land use designation of low-density residential and the zoning district of residential. These amendments will allow the 16-acre property to be developed as a 48 single-family lot subdivision, which will connect to the sanctuary development and be an extension thereof. The proposed amendments are consistent with the eastern portion of the property and the character of the community. The development team is present today to answer any questions the board may have, and we respectfully request your recommendation of approval.
Thank you. Are there any questions of the applicant at this time? Thank you.
Thank you.
May we hear from staff?
Thank you, Madam Chair. The subject property currently has two different zoning, future land use designation and zoning districts. The ordinance that I will present this evening are for the subject property's western section, and this is to become consistent with the eastern section of the property. This is a request to amend the city's comprehensive plan future land use map to change the future land use designation of approximately 6.41 acres. Approximately 4.74 acres of the subject property's future land use designation will change from rural to low-density residential, and the remaining 1.67 located in the Econolachi River Protection Area. Future land use will change from rural to conservation. The subject property is located on the north side of County Road 419, east and adjacent to Willingham Road, and the applicant is M.I. Homes of Orlando, LLC, and the consultant is Madden Moorhead and Gloom Incorporated. Comprehensive Plan Policy 1-1.14 requires the city to evaluate criteria when considering a comprehensive plan request. The results of this review can be found in the supporting data analysis report. The subject amendment qualifies as a small-scale comprehensive plan. Per Chapter 163, Florida statutes, a small-scale comprehensive plan amendment requires one public hearing before the Planning, Zoning, and Appeals Board and one adoption hearing before the City Council. Upon adoption, a copy of the amendment will be provided to the Florida Department of Economic Opportunity, The subject amendment will become effective 31 days after adoption, provided that the DEO does not review the amendment or no one files an appeal with the State Division of Administrative Hearings. The property consists of one single parcel with a total of 16.14 acres, which is the parent tract. The property currently has two future land use designations: low-density residential on its eastern section, which is 9.73 acres, and rural, which is 6.41 acres on its western section. The purpose of the comprehensive plan amendment is to designate the 6.41 acre subject property with the low-density residential and conservation future land use designation, consistent with the eastern 9.73 acre property already designated with the low-density residential future land use designation. The entire property will be developed as a 48-lot single-family subdivision named Allen's Landing, also known as Enclave at Sanctuary. On October 4th, 2014, the City Council adopted Resolution Number 962-04, approving Special Exception Use Number 178-04, to allow a religious use to locate within an agricultural zoning district. This special exception use order was issued to Covenant Presbyterian Church of Oviedo. On January 5th, 2009, the City Council adopted ordinance numbers 1448 and 1449, a respective comprehensive plan amendment and zoning map amendment, amending the future land use of the east 9.73 acre property from rural to commercial future land use designation and from agriculture to commercial C1 zoning district. The western 6.41 acre property remained for church use with a rural future land use designation and agricultural zoning district. On May 18, 2009, City Council adopted Resolution Number 198309, a non-statutory development agreement and associated master land use plan for the entire parcel proposed for the Covenant Presbyterian mixed-use site. The non-statutory development agreement authorized the development of an 11,368 square foot sanctuary building and a fellowship building up to 4,600 square feet and one residence on the west 6.41 acres. It also authorized the development of 4 commercial buildings totaling 48,900 square feet. A 2-year extension of the non-statutory development agreement and associated master land use plan was approved on February 20th, 2012 with adoption of resolution number 2472-12. On August 5th, 2013, City Council adopted ordinance numbers 1568 and 1569, a respective comprehensive plan amendment and zoning map amendment from commercial to low-density residential future land use designation, and from commercial C-1 to residential R-1BB zoning district for the east 9.73 acre property. On August 5, 2013, City Council also approved the resolution number 266013, amended and restated non-statutory agreement and the associated amended master land use plan. The east 9.73 acre property was approved for the development of single-family residential units. The western tract remained for church use and the future land use designation remained rural. The applicant requests a future land use map from rural to low density in conservation and a zoning map amendment from agricultural to residential R-1BB. For the 6.41 acre property consistent with the east 9.73 acres to allow the development to have a future land use designation and a zoning district consistent with its eastern section. The applicant intends to develop family homes to be combined with the eastern section for a 48-lot single-family residential subdivision named the Enclave at Sanctuary. The maximum utilization allowed under the proposed low-density residential future land use designation with a maximum density of 3.5 dwelling units per acre will result in 16 dwelling units. The proposed low-density residential future land use designation is compatible with the adjacent PLU designation, zoning district, and existing uses. The Development Review Committee considered the subject future land use map amendment at its Thursday, December 18, 2014 meeting and their recommended adoption of ordinance number 1613 with the 1.67-acre property located in the Econolachi River Protection Area to be designated as conservation. The applicant concurred with the DRC's recommendation. Ordinance number 1613 has been changed to reflect conservation future land use for the 1.67-acre property. City Council will conduct a public hearing on ordinance number 1613 on Monday, February 2nd, 2015. It is recommended that the Planning, Zoning, and Appeals Board recommend adoption of ordinance number 1613. This concludes the presentation for ordinance 1613, and staff is available for questions.
Thank you. Are there any questions of staff? Okay, this is a public hearing item, so we'll open it up if there's anyone here wishing to speak on this item. Just give it to the clerk. If you would state your name and address.
Certainly. My name is Mark Jones. My address is 2601 Turtlehead Cove, Oviedo, Florida. I am one of the properties that is on the boundary of the subject property tonight. I understand we're here for a zoning change. I'm not here to stop that. This is just my first opportunity to come before a board from the city of Oviedo and express some genuine concerns that the adjoining property owners do have. We've witnessed what's happened in Phase 1, a plan that's already been approved into the board here in the city. What they've done on this property is they've raised, they brought in a bunch of fill, and they've raised it about 4 feet. And the plan calls for 7-foot berm from 4 feet down to the grade of our backyards. I'm not an engineer, I'm just a dumb attorney. But I've got enough common sense to know that water seeks the lowest point. And last night we experienced about, 3.5 inches of rain here in the city of Oviedo. And I took some pictures this morning of the erosion and the washouts that occur on that 7-foot berm. And without this silt fence, all this stuff would have been in my neighbor's lanai in his back porch. And to the best of my knowledge, that silt fence isn't going to be there forever. So the purpose for me getting up here tonight is to put planning and zoning in the city of Oviedo on notice that if flooding does occur, we've got a trespass going on. And not only are they on the hook, the city's on the hook if they approve such a plan. That's why I'm here tonight. Thank you.
Any pictures that you show, you'll need to give
I'd be happy
to the clerk for evidence. Thank you. Deborah, when would the subject of flooding and water going from this track onto neighborhood tracks, when would that come up before the city?
That would come up before the Planning, Zoning, and Appeals Board and City Council during the preliminary subdivision phase. So at that point, the applicant will be required to provide a preliminary drainage plan for board consideration.
Okay, thank you. So this is not something that's before us tonight?
What's before you tonight is only the comprehensive plan amendment as well as the zoning map amendment. So at this point, we're trying to determine, or the board is to determine whether or not the proposed comprehensive plan future land use map of low-density residential is consistent and compatible. Is it consistent with what's adjacent to it? Is it compatible with what's surrounding it as well? And whether or not the proposed zoning district, which you will consider after the comprehensive plan amendment, whether or not R1BB is the most appropriate zoning district for the subject property, consistent with the low-density residential future land use designation. At this point, we are not to review any plans. There are no plans submitted for the subject property at this time for your review.
Okay, thank you. Is there anyone else from the public wishing to speak to the board on this item? Just come to the podium and state your name and address for the record, please.
My name is Harry Haverkamp. I live at 2593 Turtlehead Cove, next door neighbor to Mr. Jones here. My property also backs up to the proposed Phase 2 of MI Homes. It was interesting to listen to the previous contractor here talk to you about trees. Right behind my home is probably about a 100-year oak tree. It sits right on the property line. It was interesting to hear that when they bring in fill dirt and raise the area 3 to 4 feet, trees are going to die. Berm that Mr. Jones spoke to is going to be a 4-foot berm that slopes down to the property, right onto the property line, and back right up to these trees. Once again, has nothing to do with the rezoning of it, but these are issues that are going to come up. The planning board should look into these issues ahead of time.
Thank you. Is there anyone else? Seeing none, we'll close public comment. What's the board's pleasure?
Madam Chair?
Mr. Wright.
Page here. Okay, sorry. I'd like to make a motion to recommend adoption of ordinance number 1613.
Okay, is there a second? Mr. Sheridan, thank you. Is there any discussion? Okay, seeing none, we'll call the vote. All those in favor say aye. Aye. Opposed? Motion carries. The next item is ordinance 1614. We've heard both the applicant and staff. Is there anything else you wish to add to the zoning?
I'd just like to make one correction. I previously said that the extension is to the sanctuary development. It's to phase 1 of the enclave at sanctuary. Thank you.
Thank you. Okay, we'll open it up for public comment. Is there anyone here wishing to speak on the zoning map amendment? Seeing none, we'll close public comment. What's the board's pleasure?
Madam Chair,
Mr. Sheridan?
I'd like to make a motion to recommend approval of ordinance number 1614.
Okay, Mr. Lopez, second. Is there any discussion on this item?
Same as before, not tonight, but I believe there will be.
I do have, I'm sorry, I do have a question of staff. Ordinance number 1613 changes the future land use to a portion of this to conservation. But the zoning for that conservation is the R1BB?
Yes, ma'am. There is no zoning district for conservation in the city, so it takes on the zoning district of whatever is the underlying zoning, which is going to be the R1BB. There's no wetland zoning district, there's no conservation zoning district for any of the wetlands.
And it's the future land use that would prohibit any development?
Yes, ma'am. Our comprehensive plan prohibits any development within the Econ-Locatchie River Protection Zone except for residential dwelling units, and it has to be 1 dwelling unit per 10 acres. And there's only 1.67 acres in that particular area, so there would not be allowed a home in that particular area. We have consulted with DEO, which is the Department of Economic Opportunity, just to verify, and we're all on the same page. No dwelling units can go in that 1.67 acre area.
Thank you. Okay, is there any further discussion on this ordinance? Okay, we'll call the vote. All those in favor say aye. Aye. Opposed? Motion carries. These two items will be heard by the City Council on February 2nd at 6:30 in these chambers.
Madam Chair,
Mr. Wright?
can we take a break before we go into our next item?
Sure, we'll take a 10-minute break.
Thank you.
Sit for a while. Right, we're up.
All right.
Okay, we're back in session. Mr. Root, it's good to see you back again,
It's good to see you all.
and we will turn it over to you.
All right. Well, I know a lot of you have had construction of a similar nature before, so I'm going to try not to be repetitive.
That's behind us.
Working on that.
Oh,
It was.
You got it up there.
it was,
So I'm going to try not to repeat things I've said before, but and I'm also going to hopefully hand you some new material. But I thought we didn't go over the Scheidel case last time, so I thought we'd do it this time. And I'm not going to go over every frame. The key element here, we're going to talk about land use law a little bit, zoning and quasi-judicial proceedings
We lost everything now.
versus legislative proceedings. And we're going to talk about comprehensive planning first, which is a legislative process. And as you all know, the statutes say that the comprehensive plan is the land use constitution. So all development must be consistent with the plan. Who determines? You partly, because you are the drafter of the plan. You are the creator of the plan. You're the monitor of the plan as a body. Actually, the whole comprehensive planning process of the city is vested in this body. You can't enact the ultimate ordinance, but you do everything else but for that. Okay? Now, this case that I really want to get to the photos. This case is about a situation where a developer who had approval for a 10-phase development was going forward and developing the project. Karen and Pi Scheidel, they bought a 1-acre lot in phase 1, and they built a home. Okay? Why aren't we doing it? Now, this isn't working. How much? Going good. On a roll. I really want to get to the photos, because the photos are what's fun in this case. But Karen Scheidel, just so I'll continue with some background, she was a paralegal by trade, not a lawyer, a paralegal. And she believed that a stage of development that was occurring abutting her property, and if we could get to the photos, we'll get to that, was inconsistent with the comprehensive plan. Okay? And she, as a paralegal, on her own, challenged the comprehensive plan consistency of the development that was being proposed. The local government, hey, we're going. This is where it's at, basically. That's where they're at, basically. Oh, who's doing it? Yeah. Now I can't do anything. There we go. I'm going to hit good stuff. Okay, guys, keep clicking forward. Okay, go ahead. That's one of the lakes in Pinecrest Lakes that developed. It's a pretty development. Keep going, please. And I'm going to sound rude. Just keep going. Okay, that's a home in phase 1, obviously. Another Phase 1 home. Going.
Huge.
That's the Scheidel home. That's where Mrs. Scheidel lived. You can keep going. Okay. The issue was the property that was being developed next to her in terms of density. Keep going. You can see where her home is, and then Phase 10 of the villas at Pinecrest Lakes. That's the development that she challenged. You can keep going. And I'll give you the PowerPoint if you want it for the details. But keep going. The comp plan was very consistent, was very clear about what should and should not be developed as a matter of density on the abutting development. And Ms. Scheidel opposed it. 3-2 commission vote rejected the unanimous that this is that people ought not to get their hurt when they're on planning boards because it happens all the time. 3-2 commission vote rejected the planning commission recommendation of denial. Staff recommended approval. Keep going. We're going to get to the good stuff. The comp plan had several policies which Mrs. Scheidel relied upon, and those are outlined policies. Keep going, please. Okay, there's a nice aerial view. And you can sort of see where Scheidel's house was. Remember the map again. And you see the abutting development. That's her view from her backyard. And that's what she said was inconsistent, was the continuation of that multi-family, in her view, high-density development. Keep going. You can see probably why she didn't like it. She filed a legal action against the county. Like I said, the county found it was the development next to her was consistent with the comprehensive plan. He filed a suit. He asked for a de novo trial. You can keep going. The county argued that the judicial role was confined to appellate review, and that the county's determination of consistency was out of deference. Those are the same things I would argue, by the way. And the court should only look at the evidence that supported the board's action. Zoning, that's what the Supreme Court held. The landowner seeking to rezone property has a burden of proof. This is the comprehensive plan. It complies with all procedure requirements of the zoning board. And after the applicants met its burden, the burden shifts on the government to show why maintaining the current zoning. Ms. Scheidel was saying this development approval was inconsistent with the comprehensive plan. No matter what the zoning was, no matter what the approvals were, it's inconsistent with the comprehensive plan. The judge dismissed the resident's suit, ruled that the development was consistent. This is the lower court. This is the circuit court. Okay? Ms. Scheidel went to the circuit court, and the court said, no, you're wrong, Ms. Scheidel. The county's right. Here's the key. After the circuit court said, you lose, Ms. Scheidel, the developer said, hot diggity dog, we won. We're going to go ahead and develop our building. On that year, the District Court of Appeals reversed the circuit court and said, that's inconsistent. Then the lower court, upon rehearing the matter, said the apartments are in violation of the comprehensive That's, stop right there, sorry. This is kind of the evidence that was laid out saying why the inconsistency occurred. Okay. That's the key. Ms. Scheidel introduced this type of evidence saying why the inconsistency was there. So, the buildings were built, they were inconsistent with the comprehensive plan. Should the court say, well, you gotta tear them down? Or is that too harsh? What's the remedy? Shame on you, developer, you were inconsistent with the comprehensive plan. Ms. Scheidel, you did a good job, you won. Keep going. Or the Supreme Court, because the court said tear them down. Went all the way to the Supreme Court just said we're not going to hear this. Look what happened. That's the result of comprehensive planning. That's how important a comprehensive plan is. Eight-year legal battle. At the time of this power plant, identity. There you go. And there's, I like that. And there's the Sheffield song back there somewhere. Okay, thank you. Yeah, you can go with the other one up. I might use it, I may not. Comprehensive plan consistency is the most important thing in land use decisions. Okay, and I like to test that. Deborah, what is the role of planning for this board? When it comes to land development, like the new land development code changes that are going to come before them. What's the role of this board?
To determine if it's consistent with the comprehensive plan.
So not only do you determine whether each development is consistent with the comprehensive plan, when us folks spend hours and hours and hours drafting ordinances and submit them to you, you have to find that they're also consistent with the comprehensive plan. But if they're not, what happens then? We see what happens to a development. It should, either gets denied or it gets approved and they go forward, and if they lose later on, something bad, really bad happens. But what about ordinances? What if we bring an ordinance to you and you say, wait a minute, look, this is some provision of the comprehensive. What do you do?
Whether to recommend adoption or not.
You recommend disapproval. If you find this inconsistent with the comprehensive, if you find our work product is inconsistent with the comprehensive plan, you recommend disapproval. But if you think what if you thought it was a great idea? We come to you and say, we've got a great idea about, something I'm dealing with, murals. We haven't dealt with murals yet, but I'm dealing with murals in Sanford, and Orlando's dealing with murals now. What if there was nothing that supported murals in the comprehensive plan? You thought it was a great idea. Have murals. Okay, but if there was one thing to teach tonight, this is it: the importance of the comprehensive plan. Now, what is the comprehensive plan? It's a legislative document. Okay, it's a legislative document. So all your proceedings and all the city council proceedings are legislative. That means I can call any of you up. I'm a developer. Say, I really think you ought to change the comprehensive plan. Environmental group, I call you up. Shopping center, if you're at a baseball game, if you're at a school function, people can talk to you, and they should. That's the planning document of the city. That's something that should be talked about freely and debated freely. Okay? So that's legislative, which to quasi-judicial. Okay? Quasi-judicial isn't something you just freely talk about and say, well, it's a good idea. That's it, whatever. You had a quasi-judicial proceeding, your first item tonight. You know, that was what was that, preliminary subdivision plan? They're entitled, whoever that was, I forgot what the development was. I try to be very like that. I don't even think about who's there. Whoever that was, they were entitled to approval if they came in and they met all the codes. Okay? If they didn't, you were obligated to disapprove them. So that's, the decision is, were they compliant with the codes, or were they not? That's a quasi-judicial matter. Why? Because you're actually as judges, because you're looking at the land development code, applying it to the facts of that case. That's an adjudication. So they can call you up, but then and say, I want you to approve this, and here's why. But then what do you have to do? Say, Joe Blow called me up. Why? Because what was the guy's name who threatened to sue us so nicely?
Mr. Jones?
Mr. Jones.
I mean, and by the way, you know, approval of a plan does not cause any liability on the city or you or anybody else. You know, if you accept a drainage structure into your city drainage system, then it becomes ours, right? We own it. Say yes. We own it, but we've accepted it there. But if it's just a plan that we say that is sealed by other engineers and all that, it's not your liability, it's not our liability, it's not the city's liability. It might be an engineer's liability, it might be one subdivision's homeowners association liability to another one's or something like that. But whether you agree with this principle or not, a permitting official can permit something that is disastrous, that is totally wrong, that should have been denied. Okay, and we don't do that like that here, but there have been times in other places. Okay, so that's the quasi-judicial proceeding, and you're applying codes to a facts. That's not legislative, that's judicial. Okay, so I'm not going to go through that technicality. Now, one thing I do want to go over, the flip side of the Scheidel, real quickly. The flip side of Scheidel, that was where a developer went forward and had a big loss. Did that developer go to sue that county and say, you approved it, you rascals. If you had to tear it down, we want $3.3 million. So that's...
There was I know we skipped through slides because the burden of proof is on the developer to prove consistency with the comprehensive plan and doing so. But then there was a slide though that said where then the burden switches to what was that burden?
Okay, I'm sorry. When the applicant comes in here and says, I want my property rezoned, it's consistent with the comprehensive plan, and I complied with all the procedural requirements of the code, I paid my fee, submitted my application right, I got all the right people to do the right thing, filled in all the right blocks, I went to the right hearings, I did everything you told me to, I'm entitled to approval. They can't, they shouldn't, but they could at that point sit down. And staff would have to say, well, it's not, shouldn't do it because of this. Compatibility, consistency, concurrency, environmental, something that's linked to the comprehensive traffic or something. But in theory, the developer would sit down. Don't. Shouldn't. I mean, you come in loaded for bear and then put the city in the point of rebutting that stuff. So that's the burden that switches.
Thank you.
Okay. Now, the flip side case of that Scheidel case is the case of Pancetta. Anybody eaten it down the hatch in Ponce Inlet? Okay, that's the property that I'm talking about, the down the hatch property. Okay. So there's this, the owners of that property went to the town of Ponce Inlet at one point and said, we want to, I forgot, we want to have a mixed use development with some commercial. We do the restaurants, great stuff. Keep going. Garjon, keep going. We love it. An election happened. And guess what happened when they got to this town council? Consensus of town. Everything got denied. After years and years of work and reliance and all that. And they sued Ponce Inlet. And recently, Ponce Inlet got a $14.6 million judgment against it. The town, probably, it could be on the verge of bankruptcy if it ever had to pay that. They're still appealing and all that. But that's the flip side. When you do something wrong, and you are subject to being sued. That county that approved that development was wrong, but appeal it for wrong. What if Ms. Scheidel had not appealed that decision? Had the county been right or wrong? Right. As a matter of law, they would have been.
Because the court's already ruled in favor.
Well, no, if she had not appealed the 3-2 vote, man.
Well, that's what I'm saying. It didn't matter. At that point, if she wouldn't appeal, it would have gone anywhere.
Right. But they would have been right.
Right. Exactly.
Even though they were wrong. I mean, ultimately, it was proven. Was the county ultimately wrong? Yes. But if no appeal, they would have been right. So.
Right by default. Right by default.
Let me ask a question, because, it goes back to a situation where, I don't know if staff did it, but obviously their recommending board, body, whatever it was.
Unanimously said deny it.
Deny it, okay. And then, typically when we deny something, we usually have, we've been instructed really over time to provide some type of reason, just not to say we deny it, if we deny with reasons. So, were those 3-2 on the approving body then, did they really provide any justification of why they're not taking their own staff or recommending body's recommendation?
They sure should have.
Yeah. See, to me, that would be an error that they could be culpable, but I guess,
They should have had a nice order and had all sorts of wonderful findings about why Ms. Scheidel was totally wrong. Because then a court is going to say, well, you found all these. We don't. The judge says, I don't know about the Zula Street, and I don't know about Apple Way. I don't know what the drainage is. Judges will defer if you make findings. But you hit it on the head. This statute is what requires denials of development orders of state reasons out of the code. What code would you cite if you wanted to deny something?
Development code.
Start with the Scheidel.
Well, the comp plan, which is governing.
Comp plan is the strongest thing. And then you could get down into specific land development code provisions. But whether you approve or deny, particularly if you deny, say why. Because if you want to, if that planning board that heard the Scheidel issue said deny, didn't say why, what service did they do to the county? Nothing. Why?
So what happened with Down the Hatch? How did the city end up with a judgment against them?
Because mostly it was a stopple. Because they held hands with the developer down for many years. Let loose. After the developer had spent lots of money, had lots of reliance, had every reason, probably not legal reason, but every factual reason to think that they were going to get approved, and then they weren't. Which is that's on appeal, but it's been on appeal and then back, and then they just had a jury trial on the damages. And it was $14.6 million judgment.
They ain't got that kind of money.
Huh?
They ain't got that kind of money.
No, they don't. It's a little tiny.
It's
So anyway, But that's the distinction between legislative and quasi-judicial in its most stark form, okay? One is just loosey-goosey legislative. Do what you want, talk policy, grand ideas, let the community have its say on everything, at any time, at any place. The other one is, you're like the people who wear black robes to work every day, and you got to act that way. And what happens if you don't? I'm going to stop at on this point. What happens if you don't? Well, it's the case of Florida Institute of Technology versus City of Melbourne. There was a denial there. Another issue, Florida Institute of Technology appeal versus the City of Melbourne. Here's what the court said. Another issue raised by Florida Institute of Technology was the obvious bias and partiality of councilperson Poole and her participation. The court is not unmindful of the pressures that are placed on public officials. And there are. On the one hand, they are pressed to allow growth only that is consistent with available roads and services. On the other hand, they are pressured by landowners who wish to develop their property in such a manner that results in the largest return of capital pleasure. And still they are subject to pressure from neighbors of property to be developed who are quite understandably upset by the slightest change in use of adjoining vacant property. All these interests make it difficult to make decisions in such cases. However, being a member of City Council does carry certain responsibilities. One of those applies to you all too. One of those responsibilities is to follow the law and in a quasi-judicial proceeding be a part of the jury. In this case, councilperson will clearly apply and that's the appearance plan. Advocated against the proposed project. She marshaled opposition to the project he presented to the City Council. It appeared at the Department of Transportation hearing on the issue of a curb cut on Babcock Street. All of these add up to showing a bias on her part against the proposed project. Now, some people, in past times actually, you would have said Councilperson Poole is an active, good councilperson. That's what you're supposed to do, right? That's just not the case anymore. Once you take a position like this, I'm a judge. Councilperson Poole was going to be a judge, but the court said and she voted, by the way, later on. That's part of the problem. And the court said she should not have voted. The whole proceedings was tainted because of her. So that's the result of not acting in a quasi-judicial role when you have one. Okay? Any questions? Because I don't want to keep going. Oh, there is one other thing I want to focus on. I'm going to hand out some handouts. You can take them all. I always do. You know I do that. And you can pitch them in. But one thing I do want to mention tonight, because of something that's occurred recently when I represented a commissioner up in Deltona. And I'm going to hand you another copy of this, which we've had before. For the Commission on Ethics Guide, Sunshine Law, and Ethics Law. Make sure, and I know staff's good about this, make sure you know who the applicant is, who the owners are of the matters that you act upon. Okay? Because this is going to hurt my feelings to say this, but if you ask me if you have a conflict of interest and I tell you you don't, and it's okay to vote, somebody files a complaint against you, the Ethics Commission, and says you violated the Code of Ethics, and you tell the Ethics Commission, Attorney Cruz said I could vote. It's not. It is not a defense. So you need to know who the parties are before it. Seen a little bit of slack, not this city particularly, but in some other cities where, there was nothing in the agenda packet about who the applicant was. It said address, but do you know who owns every piece of property at every address in the city of Oviedo? I don't think you do. So you just see an address, you should say, who owns that? I mean, who's the owner? And who is the applicant? If it's a developer, someone says, I'm here to represent the owner. Who are you? I'm MI Homes. Okay, now you know that. That's important to know. That's the pitch there on the code of ethics. Then after yes, sir.
Go back to some, because like I said, that example you used, the city of Melbourne, where the councilperson went before.
Councilwoman Poole.
Example, if we have something that we're just like vehemently against, you know, and once we've passed our recommendation and we show up at council to follow, to make, you know, we came before council and said, look, you know, obviously I can do it as citizen of Oviedo, but can I actually come before the board, the city council, as a member of the PZA, and say, you know, we voted for this, against this is why we don't think it should be approved tonight, blah, 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 blah. I mean, are we putting ourselves in any position?
Absolutely. I highly recommend it, and I say this to everybody I've ever.
Not saying I'm ever going to do it.
No, I've seen it done, and highly recommend not to. Here's a couple of reasons why. What if it gets sent back to you? First of all, if let's say you're here, and I'm up there, and I'm acting all dispassionate and just doing what I think is the right thing, and then you go to the city council, and I'm a firebrand about it, you might suspect that I wasn't so objective when I was sitting up there, right? Also, what if a council says, well, you know, there's some other issues here that we need to have looked at again by the PZA. Let's send it back. Now you just probably knocked yourself off the dais because you can't vote. And then there's another reason, too, and this is an actual case. Despite my caring legal advice, a couple of members of a planning board, both wonderful people. I mean, they're both wonderful people, very bright people, caring people, zealots, cared about their city, and came to the city council meeting and sitting next to each other in the audience. And one of them got up to speak to sort of say, well, you know, here's what we were talking about at the planning meeting. Here's what he said. Well, you know, Joe and I are both on the planning board, and we were talking about this while we were listening to you. What's the problem with that? Sunshine. He was just, he just admitted to violating the sunshine. But that's something that can just happen. You don't even think about it. He didn't think about it. He goes, oh, my gosh. Do you think anybody's going to complain? I don't know, but I hope not. So, any questions? I'm going to be through. I'm going to hand out some material. Questions?
Did you get asked that question I had today about that disclaimer of the LA? Obviously, you know, from before you came in, staff said that your recommendation was to have it removed.
Have it removed, and if they want to write a letter saying how they disagreed with that, then they can write a letter and put it in the file. And then they're on record, and if they're worried about their liability insurance, they're covered. But we ought not to allow, you know.
Well, I guess the question I had was whether or not, was there anything in our, if we didn't have your recommendation, obviously, was there anything that we could have put in there that basically said we want it removed, and again, with reason, you know?
Well, it's not, I would just say it's not pertinent, any more than if I submitted a plat and I put a note on it as the surveyor or developer or engineer or architect saying, I think the city of Oviedo's zoning regulations are stupid. Well, they have a right to say that.
Sure.
But not on the plat. Right?
He did go a bit overboard with their,
I mean, it's not.
with their notes on
I
it.
thought you were going to tell me I went a little overboard.
I'm not trying to infringe upon their freedom of speech. It's just that's not the appropriate time.
No, I was quite surprised when I read that one.
That's the answer I was looking for, is that basically in a situation like that, is that we can still have some type of forum in the sense to ask whether it's not applicable or pertinent. I like that word, pertinent.
I would have that same opinion if they wanted to put the Declaration of Independence on. not pertinent.
Yeah.
Okay, and the last thing I'm going to hand out is it's a really good little PowerPoint presentation from Michigan. These are not Florida's, right? Florida sources, but it's good stuff. And it's good little things to remind you about, you know, what you're doing as a board member. Complaints, comments? All right, thank you very much.
Thank you for coming to see us, Lonnie.
Good seeing
We
you.
haven't seen you in a while, and you always give us good information.
Come back when we talk about the signs.
Signs?
Are you welcoming another sign?
Well, you know
You know it's coming. It comes every 3 meetings.
But,
That's something else about
you know,
it.
not that, I don't want to overdo my invitation here, but the Supreme Court of the United States just heard arguments the other day on the town of Gilbert, Arizona, about a sign issue. And depending upon how the U.S. Supreme Court rules, these folks could be busy because
Means it will be busy.
Depending upon how council votes, the city's own portable sign may be illegal and never be able to be used again.
What was the,
well, what Gilbert allows signs in the right-of-way, if they're political or free speech signs, basically. Okay, and they allow them for 6 months. I'm going, you know, this is best my recollection. But for directional signs, such as church this way, which is who sued, church, you know, they're not allowed for that long period, strictly regulated. The church said, you don't know whether our sign is legal or not unless you read it. And you have to read a sign to know whether it's legal or not. It is what, Deborah? An example.
What is the term? Unconstitutional?
Content-based.
Content-based,
It's
yeah.
content-based regulation. You have to read the sign to know if it's legal, and it's content-based. Or may say something different.
Lonnie, where is that case now?
The U.S. Supreme, it was argued Monday.
Was it? Okay.
Actually, the person who helped Seminole County with their adult, when we were doing the adult, I don't know if how many of y'all remember this, the adult entertainment wars in the 1990s, David Cortman helped the county, was one of the people who helped us. He argued it in behalf of the church, Supreme Court. It's going to be interesting.
So you'd look for a decision in 6 months, a year?
Oh, it'll happen. It's within 6 months for sure, yeah.
Okay. Thank you, Lonnie.
Thank you, all.
Thank you. Okay, we have no other discussion items on our agenda. Does anyone have any else we need to discuss tonight? Okay, seeing none. Our future meeting dates are January 27th, February 10th, and February 24th. Do we know if we have items?
We do not have any items for January 27th, but we will have some in February.
Okay. Oh, I see on here you've got January 27th canceled. I didn't read that far on the line. If there's nothing else, do we have a motion to adjourn?
second?
All those in favor say aye.
Aye.
We stand adjourned.